Hi everyone, our case for today is Romarico Vitug versus Court of Appeals and Rowena Faustino-Corona. The facts of the case are the following. Romarico Vitug asked authority from the probate court to sell certain shares of stock and real properties belonging to the estate of the late Dolores Luchanco Vitug to cover his advances to the estate which he claimed were personal funds. The advances were spent for estate tax and deficiency tax. The same were withdrawn from a Bank of America account. Rowena Corona, executrix, opposed on the ground that the funds in the Bank of America were conjugal partnership properties and part of the estate. Vitug insisted that the funds are his exclusive property, having acquired them through a survivorship agreement executed with his late wife and the bank. The probate court upheld the validity of the agreement and allowed the sale. On appeal, the Court of Appeals ruled that the survivorship agreement constitutes a conveyance mortis causa which did not comply with the formalities of a valid will. Assuming it was a donation inter vivos, it is a prohibited donation. Hence, the present petition. The issue which the Supreme Court held to resolve was whether a survivorship agreement is valid. The Supreme Court held that in the affirmative, stating that such conveyance is not one of mortis causa, which should be embodied in a will. Neither is it a donation inter vivos because it was to take effect after the death of one party. More so, it is not a donation between spouses because it involved no conveyance of a spouse's own properties to the other. Here, when the spouses Vitug opened the savings account, they merely placed what rightfully belonged to them in a money-making venture. They did not dispose of it in favor of the other. It is merely a contract that imposed an obligation with a term. The term being is death. Survivorship agreement is an aleatory contract. One or both parties reciprocally bind themselves to give or do something in consideration of what the other shall give or do upon the happening of an event which is uncertain or which is to occur at an indeterminate time. A survivorship agreement falls within the uncertain category where the risk was the death of one party and the survivorship of the other. Although a survivorship agreement is per se not contrary to law, its operation or effect may be violative of the law in case it is used to hide an inofficious donation, transfer of property to defraud creditors, or to defeat the legitim of a forced heir. It may be assailed and annulled upon such grounds. Here, there was no such unlawful purpose.